We have one more conversation for you here for Chicago Live before we get to the 4 o'clock news. And this is one of those discussions that's hard to have, but at the same time super important to have, that we are knowledgeable about the things that are taking place in our communities and the fights to protect especially our young people. So Clifford Law Offices just obtained a record $50 million verdict for a young camper who, unfortunately, was raped at a Chicago area kids camp. And I have Bradley Cosgrove, an attorney and partner at Clifford Law Offices, who is here with us now to tell us what happened here. Thank you so much for your time.
Hi, how are you?
You know, I would be so much better if things like this, in terms of the event that even left this young person to end up needing you all's help, weren't happening. But give us the background here on this story.
Sure. This is a case for at least our time period right now, being that it's summertime, is something that's highly relevant and important to families throughout Chicago.
Mm-hmm.
This is a case involving a young boy whose parents wanted to sign him up for summer camp, much like many of us all have done with our children throughout the years. And mom and dad actually had a little boy. His name, he was 8 years old, and he wanted to go to this climbing camp, indoor rock climbing at a company called First Ascend. And they offered a rock climbing camp. It was week long. There was about 7 sessions where kids could go from 8 in the morning till 4 o'clock at night. And they essentially accepted the kids into their possession and were in charge of the children throughout the day and were supposed to keep them safe and protected from any type of bad things from happening. Unfortunately for my client, there was another camper who was admitted into the camp. And when he came into camp, the climbing facility was told that the boy was not allowed to go in the bathroom alone with other children. And we think that that request was so unusual and so weird and so unnormal or not normal that what needed to take place is that the camp needed to ask further questions and to try to find out additional background. The evidence in our trial demonstrated that had additional questions and information been looked into, the camp would have determined that the 13-year-old boy who was trying to go to the summer camp had a history of sexually inappropriate conduct with other children. The mom and dad of this 13-year-old boy knew that the kid had some deviancy and were trying to help him, as he was an autistic kid that was a big, strong kid, and they were trying to help him, get him into a structured program where he had firm rules and certain limitations so that they could have him out in public and socialized with normal kids. And they had asked for a special instruction. There was a safety plan in force that required that if a kid was going to go to the bathroom, he needed to be supervised and not be allowed in the bathroom alone. The evidence in our case demonstrated that for about 50 minutes, the First Ascend climbing facility lost supervision of the boy and didn't follow the safety rules, and the boy unfortunately attempted to sexually assault one child in the bathroom. That child escaped, was able to get his sister, but unfortunately a few minutes later the child lured my client into the bathroom and sexually assaulted him during the 50-minute period of time where he was unsupervised, and basically the camp counselors totally lost track of him. He was in the bathroom, the very place they were warned not to allow him to go alone. And he was in the bathroom alone for 50 minutes with attempted sexual assault and ultimately a sexual assault that took place on my client. The case was filed back in 2022, and the case proceeded in Cook County, and against First Descent. First Descent denied negligence, denied, in fact, that the rape even took place, all the way up until the day of trial. And when they got to trial, they still denied that they did anything wrong, and it required a jury to find a verdict that First Descent was negligent, but the jury actually found more than that. The jury found that First Descent was willful and wanton, that they had a conscious disregard for the safety of the campers. And as a result, the court permitted the jury to award punitive damages as well. So there were $49 million in compensatory damages and $1 million in punitive damages that were awarded late last night.
This is so incredibly heartbreaking on so many levels, and that 50 minutes is all it took for so many life-altering things to happen. I do want to say, because you mentioned the fact that that the camp has denied things all along, we did get a statement from them. It says, "We are heartbroken that this horrific criminal act occurred in one of our gyms, and our hearts go out to the young person who experienced this trauma and his family. While we respectfully disagree with the verdict, nothing about that changes our compassion for the victim or the seriousness of what occurred. Our legal team is exploring post-trial issues and options, including but not limited to the possibility of an appeal of issues from trial and the jury's verdict." What is your response to that? I mean, it seems in them saying occurred, they are saying it happened, but also saying that they disagree with the verdict.
Too little, too late. This case has been pending for 4 years. Where was this compassion years ago when the case was first filed? Where was this compassion and heartfelt statements when they were denying responsibility, when they were denying that the rape even took place? This is post-judgment attempts by First Descent to save face in the public. If they really felt the way that they claim they do in your statement, where were these statements 4 years ago when the lawsuit and the incident first took place? I think this is lip service to try to save peace in the public, and candidly, I think it's too little too late.
And just on a final note, I want to circle back to the young person, this 8-year-old child who was involved here. How are they and their family now?
Every day is a struggle for a victim of sexual assault, not just in this case, but for all the people that have dealt with it throughout our community and throughout our world. Sexual assault is a violent crime. It's something that is nasty, and it lives deep down in people's soul. And it's something, when it happens to you and you are the victim and you are the survivor of a sexual assault, it sticks with you for a lifetime. This isn't like an event that goes away. This is something that sticks in your heart and your brain and your soul for the rest of your life, and you never get over it. Can you learn to deal with it? Can you learn to cope with it? Sure, but it never goes away. It's always there, and you always have a fear that something like that could happen again. We believe in the case like this that it never should have happened. When a little child is entrusted to a camp, a summer camp has to follow through on its promise. Its promise is to protect and supervise. And we think those promises were violated, and we think, point blank, the evidence demonstrated that this obligation by First Descent was grossly ignored. And the jury concluded, consistent with our beliefs, that this is a preventable event that never should have happened.
Attorney Cosgrove, thank you for your time today, and thank you for fighting for this child. Thank you. We appreciate it.
It's always great to see you. Thank you very much for having us.
Take care.